legalization of marijuana affects the workplace. As you all are aware, and part of why you're here, legal marijuana is in many, many states. We're going to go over and I'll give you a list of the states that they are in. I have not looked to see for the November election how many more states have it on their ballots, but it will be interesting to see what happens in November and how many more states join this legalization. I figured with this topic there are certainly many jokes that can be made. Hang on. Sorry about that. Okay. So I figured we should get one of the jokes out of the way. How did some states legalize marijuana and high voter turnout? So I mentioned about the number of states that we have that have enacted legal marijuana for medical purposes, and we will differentiate between medical marijuana and recreational marijuana. Medical marijuana means that you have a physician's note and that you have some sort of condition that has been verified by a physician that the medical marijuana can assist with the symptoms of. So here are the states currently that have medical marijuana laws on the books, and there are 29 of them in addition to District of Columbia. One of the themes that you will see as we go through this workshop is that we have the states that have enacted and legalized marijuana, whether it's for medical or recreational purposes, but we have the federal laws on the books still criminalize marijuana. So it's interesting that it's been legalized in District of Columbia where our laws are made, yet the federal legislation does not consider marijuana legal. So moving on to the states that have enacted recreational marijuana, we have 9, and also District of Columbia has also legalized recreational marijuana. So again, the dichotomy there between our federal laws still criminalize it, yet in Washington, D.C., it is legal for both recreational and medical marijuana purposes. And there are many justifications for legalizing marijuana. We have compassion. Certainly people who are, you always hear about people undergoing cancer treatments, that it helps them. There's a lot out there about children who have epilepsy, that it helps with to reduce or sometimes eliminate seizures. So there are a lot of compassion reasons for justifying certainly medical marijuana. Another is the revenue that it brings. We're going to look in a little while to Colorado, which is basically the model and the experience we can all look to see how they have profited from the legalization of marijuana, and certainly it brings a lot more jobs around. You'd rather have these jobs be legitimate jobs where people can earn money and pay taxes rather than people who were, selling marijuana illegally. And there are also a lot of people that feel that free choice, let people decide for themselves. The other is that it deters drug crimes. We've all heard about the effects of marijuana on 3 strikes, and in fact some states are reviewing their convictions and reconsidering the prior convictions where somebody has been held to very long and harsh sentences based on marijuana convictions. So some states are reviewing those and issuing leniency and letting people out when those convictions have been based on marijuana convictions. Let's see. We have the Compassionate Use Act of 1996, and this is, if anyone wants to look at the language of it, Health and Safety Code Section 11362.5 provides that persons using marijuana under the care of a physician, so this is what enacted in California, medical marijuana, are not subject to criminal prosecution by the state. And this Compassionate Use Act comes up in some of the cases that we're going to review briefly that interpret the California legalization of medical marijuana and how that interplays with the federal law. When this passed, it was on a very small margin in 1996. It passed on a vote of 55.6%. It was the first ballot initiative at the state level that caused a conflict between state and federal law, and we'll see how that plays out. Then we moved to the recreational legalization in California, and certainly many states that have, we're going to focus on California. Obviously, I'm in California, but many states have gone through and have similar legislation and similar content of their legislation for legalizing medical and recreational marijuana. So recreational marijuana in California, this was just back in the November 2016 election. It was Proposition 64, which legalized recreational use of marijuana for adults aged 21 and older, so it's similar to alcohol, and it permits smoking in a private home or at a business license for marijuana consumption. Just like alcohol, smoking marijuana while driving remains illegal, and adults aged 21 or older may possess up to 28.5 grams of marijuana and 8 grams of the concentrated marijuana. Marijuana possession on grounds of a school, daycare, youth center, excuse me, it does remain illegal, and individuals can grow up to 6 plants within their home as long as the area is locked and not visible from a public place. So you can't have, don't be growing pot plants in your windows where it faces the street. It does need to be not visible to the public. The recreational marijuana regulations in California, the Bureau of Medical Cannabis Regulation has been renamed, starting in 2016, the Bureau of Marijuana Control. Excuse me. This bureau is responsible for regulating and licensing marijuana businesses, the distribution, retail sales, and operation, as well as homegrown activities. So you have the state administration, the state agency that regulates marijuana, yet different counties and municipalities can be able to restrict where marijuana businesses can be located. And these local jurisdictions, pursuant to the state law, are allowed to reasonably regulate the personal growth, possession, and use of marijuana plants. With the counties and municipalities, you certainly have zoning ordinances that can be in effect in terms of how, when you have a dispensary, how close a dispensary can be located to, excuse me, a school or a religious institution and things like that. So moving on with some of the regulations in California, Proposition 64 explicitly provides no employment protections, which is interesting. So if you see here, nothing in the code section, Prop 64, shall be construed or interpreted to amend, repeal, affect, restrict, or preempt the rights and obligations of public and private employers to maintain a drug and alcohol-free workplace, or require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, etc., of marijuana in the workplace. So let me repeat that part. There's nothing in Prop 64 that requires an employer to accommodate the use, consumption, possession, transfer, display, transportation, sale, or growth of marijuana in the workplace. Prop 64 also does not it does not affect the ability of employers to have policies prohibiting the use of marijuana by employees and prospective employees, or prevent employers from complying with state or federal laws. So here it is right here. Even though you have, everyone talks about the legalization of marijuana, in effect all it does is that it decriminalizes it. So the laws are still in place that employees cannot use marijuana in the workplace, so they cannot use it in the workplace. This law basically prevents law enforcement, state law enforcement, from criminalizing the behavior. So Prop 64, it only provides criminal protections, no employment protections. Employers are not required to accommodate according to the statute. And looking to the first case we're going to review, the California Supreme Court found that the Act provided no protection. A lot of the cases that get published are cases that, really exemplify and have the best situation coming forward to make law on these cases. So in this case, which was back in 2008, so this was just under the medical marijuana law, the court decided that California's Compassionate Use Act of 1996 does not address the employer-employee relationship and only gives a medical marijuana user a defense to some state criminal charges involving the drug. In this case, I think the facts are pretty important here, the plaintiff suffered from muscle strain and back spasms resulting from his injuries while he was in the United States Air Force. He began using marijuana in compliance with his doctor's recommendations under California's Compassionate Use Act. After his employer offered him a job as a promotion, it required him to undergo a drug test. And we're going to also go over when you can and can't perform drug tests. As expected, he tested positive for THC, which is a chemical found in marijuana. The employer immediately suspended him and then fired him, saying that he was being fired because of his marijuana use. Mr. Ross sued, alleging disability discrimination under California's Fair Employment and Housing Act, which is known as FEHA. He alleged that his employer violated FEHA by failing to make reasonable accommodations for his disability. He also claimed his termination violated public policy. The California Supreme Court, so the highest court in California, agreed with the lower court that the Compassionate Use Act was not intended to apply to employment law. So here, cannot have had a better plaintiff to bring this type of case. Here, his injuries were due to his service with the United States Air Force, and yet he still was not found to have employment protection. So I'm going to move on to discuss some of the taxes that come about through the legalization in California. There's a cultivation tax of $9.25 per ounce for flowers and $2.75 per ounce for leaves, with the exceptions for certain medical marijuana sales and cultivation. A 15% tax on the retail price of marijuana, and those taxes can be adjusted starting in 2020 for inflation. And in addition, local governments can also levy additional taxes on marijuana. And it's just how local taxes will differ depending on what city you're in. You may notice that, if you go to, if you buy something at, let's say, a Gap in one city versus the other, the same item will come to a different amount because of local taxes, which differ from city to city, so the same can be done with marijuana. So moving on to some of the penalties under the law, individuals under age 18 who are convicted of marijuana use or possession are required to attend drug education or counseling programs and complete community service. Selling marijuana without a license is punishable by up to 6 months in a county jail, a fine of up to $500, or both. And then I mentioned that we look to Colorado since they have years of experience behind them with the legalization of recreational marijuana, and we can look to the economic benefits that have happened there. Certainly all the new businesses and jobs that have been created, there are over 1,000 medical dispensaries now licensed in Colorado and over 500 retail stores. Certainly new jobs have been created relating to packaging, horticulture, commercial leasing, warehousing, marketing, web hosting, security is a big one, transport, and then all the edibles. And they've even developed barcoded tracking for seed to bud, so you can track, the exact marijuana strain that has been used from the time it was a seed until it's in a usable form. And I don't know if this is true, but I have heard that in Colorado currently that there are more pot shops than Starbucks. So that would be an interesting number to take a look at, although it's obviously changing all the time. In Colorado, the sales revenue in ballpark figures, in 2014, when it was first enacted, there was almost revenues of $700,000. And in this year, it's estimated to be at $1.5 billion. So obviously a huge economic growth for Colorado, and they have a 25% tax on the retail sales. So there's millions and millions of dollars coming into Colorado for tax revenue. Certainly it's not all, there are not all positives if you are pro-legalization of marijuana. There are some negative impacts that we can look at Colorado and see what they've experienced. There are medical issues. There have been dramatic increases in ER visits for marijuana intoxication, and that's, that's happening here as well. Certainly people who are not used to ingesting marijuana, whether in edibles or smoking form, are not practiced with how much they should ingest. There's been unintentional ingestion by children of the various forms of edible marijuana with inconsistent dosages. So that makes it very hard to try to treat when it's hard to tell how much they've had. Certainly a child who sees a cookie or a brownie would have no hesitation to take it, not knowing that that it's laced with marijuana. One of my best friends is actually, is actually a veterinarian, and she has a huge increase in dogs that accidentally eat, the cookies and the brownies and the edibles, and that's a very big problem for animals to have. I know some people talk about THC helping their dogs, but you certainly do not want them eating doses that you've not authorized, and chocolate is also not good for dogs as well. Also, people talk about how great marijuana is for health problems. It's actually more effective for treating the side effects of those symptoms. It's not known to be a cure for ailments, but it's more of a treatment which helps with the side effects. So other negatives that can be seen from the experience in Colorado, there are increased marijuana-related accidents, deaths, non-fatal accidents, and traffic violations, and increased arrests for driving under the influence, and public intoxication. Also, it's a cash-only business because the federally insured banks will not accept the pot manufacturers or dispensaries as customers because it's still illegal under the federal law, and as we know, cash incentivizes crime. Another issue that some employers are having in places where marijuana has been legalized, either just for medical purposes or for recreational, is that a lot of employers who do legitimate pre-employment screening are having trouble finding clean, quote-unquote, clean employees who can pass a drug test. I recently met with a new client who is a production company, and so they employ a lot of directors and writers and creatives in the entertainment industry, and I was going over with them about what they would or would not like as their policies, and I talked about whether they would want to do pre-employment drug screening, and they were very unanimous in saying that no, they cannot do that because they would have trouble hiring any of the people that they use because none of them could pass the drug test. So, that is another area to look at, is that if you're going to do pre-employment drug screenings, what are you going to do with those results? And we'll talk about that in a little bit. Some other employer issues that have come up with legalization of marijuana, we have all these interplay of all these laws. We have the Controlled Substances Act, which we're going to discuss all of these, the Americans with Disabilities Act, Drug-Free Workplace Act, Family and Medical Leave Act, U.S. Department of Transportation regulations, lawful off-duty conduct statutes, and then the duty to provide a safe workplace. So we're going to go through some of these pretty quickly. So the Controlled Substances Act currently lists marijuana as a Schedule I substance. So this means that it is illegal to possess or use any Schedule one drug under federal law. It is illegal to grow, distribute, use, or possess marijuana under federal law. Under federal law, doctors cannot prescribe it. I've heard recently of an issue because veterans who go to the VA for medical treatment, those doctors are prohibited from prescribing medical marijuana. So that is a problem, because certainly with PTSD, marijuana is a very useful tool for helping to deal with that. And then we have some cases that have gone all the way up to, the earlier case we discussed was the California Supreme Court. We have cases that have gone to the United States Supreme Court saying that the Controlled Substances Act trumps state law for federal criminal prosecution, meaning it takes precedence. So we have one of the cases, the United States versus Oakland Cannabis Buyers Co-op, and this was back in 2001. In this case, under the California's Compassionate Use Act of '96, remember that's what made legal medical marijuana, the Oakland Cannabis Buyers Cooperative was organized to distribute marijuana to qualified patients for medical purposes. The United States sued to enjoin the co-op and from doing this, saying that it violated the Controlled Substances Act, and it went on appeal, and the Court of Appeals said that the medical necessity defense was a legal defense to the lawsuit by the United States. So this then went to the United States Supreme Court, and the question that was presented there was, does a medical necessity exception to the Controlled Substances Act's prohibition on the manufacture and distribution of various drugs, including marijuana, exist? And this was a unanimous opinion, and it said that the holding was there was no medical necessity exception to the Controlled Substances Act's prohibition on manufacturing and distributing marijuana. So that was not able to be a defense to the lawsuit trying to enjoin the co-op from distributing marijuana to its patients. We also have the case of Gonzalez versus Reich, and this was also a United States Supreme Court case. And in that one, the DEA, the Federal Drug Enforcement Administration, seized doctor-prescribed marijuana from a patient's home in California. And after that, a group of medical marijuana users sued the DEA and the U.S. Attorney General at the time, John Ashcroft, in federal district court. This eventually made its way up to the United States Supreme Court, and the question there, similarly, was, does the Controlled Substances Act exceed Congress's power under the Commerce Clause as applied to intrastate cultivation and possession of marijuana for medical use? And this one was a 6-3 opinion, and in this one the Supreme Court held that the Commerce Clause gave Congress the authority to prohibit the local cultivation and use of marijuana despite state law to the contrary. So here we see that federal law, again, is prevailing despite what state laws have held. So dealing again with what the federal message has been, in 2009, under the Obama administration, in October 2009, the Justice Department issued a memo saying that it advised their federal prosecutors not to prosecute medical marijuana patients in states where it has become legal. And that was Attorney General Eric Holder, and he said, it will not be a priority to use federal resources to prosecute patients with serious illnesses or their caregivers who are complying with state laws on medical marijuana. But we will not tolerate drug traffickers who hide behind the claims of compliance with state law to mask activities that are clearly illegal. So this memo was issued to provide clarification and guidance to federal prosecutors in states that have enacted laws authorizing the medical use of marijuana. It was stated that this was an effort to make the most efficient use of limited resources and that prosecutorial priorities should not target individuals whose actions are in clear and unambiguous compliance with existing state laws. So this was what was happening under, and the advisement for federal prosecutors under federal law, but that obviously changed under the new administration. In 2017, the Attorney General, Jeff Sessions, confirmed that he found that marijuana remains an illegal drug and that federal prosecutors will continue to aggressively enforce the statute. And he has talked a lot about how dangerous he thinks marijuana is and that it's of an utmost priority to enforce the rule of law. So whereas under the Obama administration, they found some deference to state laws, currently that is not the case. So it'll be interesting to wait and see what happens with that. Going on to some other federal laws to see how marijuana is dealt with there, we have the Americans with Disabilities Act. And just for some overview, the ADA is a federal law which protects those with disabilities. States have different laws that also provide protections, but this is the federal law. Under the ADA, it has been found that current marijuana use is not protected. And the case we have there is called Barber versus Gonzalez. And this was here it is. In this case, the plaintiff's use of marijuana was considered an illegal use of drugs as defined by the ADA, and it was found that the defendants did not violate the ADA when they took action against the plaintiff on the basis of his marijuana use, whether Washington law allowed such use. So there again, they found that the federal law, the ADA, was not required to acknowledge and allow the use of medical marijuana. So the ADA excludes users from being a qualified individual with a disability. We have prescription use can be allowed under the Controlled Substances Act, and we're going to talk about that in a moment. And there are some narrow research programs which do allow, federal research programs which do allow for tests and research on the effects of marijuana, but certainly use is not yet allowed. So under the ADA, there are some protections that are provided for former or recovering addicts because the ADA and state laws that protect disabilities do find drug addiction to be a disability, but it does not require condoning current use. The presentation of a medical marijuana card does not end the interactive process or provide an accommodation. So an employee cannot come to an employer and say, look, I have a marijuana card, and as part of the interactive process, you need to accommodate this. That is not required under the ADA. I want to talk about dronabinol, which is an FDA-approved and may be lawfully prescribed. It is a synthetic form of THC that's typically in a pill form. It is FDA-approved, and I have not seen a case come up yet where somebody was prescribed dronabinol and tested positive on an employer's drug test and then sued saying that he or she was lawfully taking a prescription that's FDA approved and therefore could not be terminated. So I've not seen that case come up because my understanding is that dronabinol will cause a true positive marijuana result, so it will be interesting to see what happens, and I'm sure that situation will come up. So under federal law, there is no employment law protections, and we've seen even in California, the California statute does not provide employment law protections. Illegal use of drugs means use, possession, or distribution that is unlawful under the Federal Controlled Substances Act. The exception is that illegal use of drugs does not include use of a Schedule I through IV drug taken under the supervision by a licensed healthcare professional or other uses authorized by the Controlled Substances Act or federal law. So there's still no allowing of medical marijuana for federal, under federal law. But there's the case of James versus City of Costa Mesa. Because Congress defined illegal drug use in the ADA by reference to federal law, and medical marijuana is illegal under federal law, it is not protected by the ADA. The Americans with Disabilities Act, individuals currently engaging in the illegal use of drugs, including Schedule I marijuana or any other controlled substance, are not protected. Employers may adopt reasonable policies or procedures, including drug testing, to ensure that an individual is not engaging in the illegal use of drugs. The ADA also says that an employer may require employees to behave in a manner that meets the Federal Drug-Free Workplace Act requirements. So here we have the ADA referencing another federal act and saying that that is correct and that must be adhered to. The unlawful manufacture, distribution, dispensation, possession, or use of a controlled substance is prohibited in a person's workplace. The employee must abide by the terms of that statement. The ADA also permits employers to hold employees to standards imposed by other regulations, and some examples that are provided. The NRC is the Nuclear Regulatory Commission, DOD is Department of Defense, and the DOT is Department of Transportation. And certainly the Department of Transportation has very rigorous drug testing policies, as you can imagine they would. Federal government contractors with over $150,000 in contracts and federal grant recipients of any amount must publish a drug-free workforce policy that prohibits use or possession in the workplace. They have additional regulations that are required of them. They must report drug-related crimes occurring in the workplace, and their contracts and grants are at risk if there is non-compliance with this law. The other federal law to look into after the ADA and the Drug-Free Workplace Act is the Family and Medical Leave Act. The Family and Medical Leave Act is a federal law that allows employees to have protected time away from work to deal with health conditions, and then there's the California counterpart to the Family and Medical Leave Act, which is the California Family Rights Act. Treatment and rehabilitation for addiction is generally considered a serious health condition, but absences caused by illegal drug use are not protected. So the way that it works is if you are a current user, the FMLA, just like the ADA and the other acts, will not protect you for current drug use. However, if you are not using, but say that you need treatment or rehab for an addiction, then that does qualify as a serious health condition, and you can get workplace protections for that. So the U.S. Department of Transportation, I mentioned that they have very rigorous testing requirements. They've been very clear in their statement that medical marijuana is not a basis for an MRO, which is a medical review officer, to report a negative result. So medical marijuana will result in a positive screening for Department of Transportation and the negative things that will come from that. So I mentioned that we would go over employment drug testing and when that's permissible in California. In California, it is only permissible in 3 situations. One is post-offer pre-employment, and that means that you have interviewed a candidate for a job, you have offered them the job and said that they have the job, but it is conditional upon passing a drug screening. So you are always allowed to do it in that situation. The other is upon reasonable suspicion. And reasonable suspicion means that you have a reasonable basis for suspecting that somebody is currently under the influence of illegal drugs or alcohol. When somebody calls me that they want to do testing for reasonable suspicion, I always tell them to make sure that what they are documenting is a pretty objective standard to be able to say that they have a reasonable basis to think that the person is under the influence. And those are things like, slurred speech and glassy eyes and observable things that you are able to document that the person is under reasonable suspicion. It used to be that reasonable suspicion included anyone who was involved in a workplace accident, although I have seen cases that have curtailed that a bit. It used to be if anyone is involved in a workplace accident that they get tested. However, the reasonable suspicion should still prevail in that situation. So if somebody is driving a forklift and crashes into someone who's just working at their workstation, the person who was hit, there's really no reasonable suspicion to test that person if they were just working at their workstation. Certainly there is reasonable suspicion to test the person that was driving the forklift under that scenario. It also is permissible to the only time it's permissible to do random drug testing is when you have safety-sensitive situations, and those are things like forklift drivers and things that are truly safety-sensitive. Then and only then is it permissible to perform random drug tests. So moving on to off-duty and legalized marijuana, in California, employers may not regulate or control the off-duty lawful conduct of their employees. But how does that relate to marijuana if it's been legalized and employees do it off-duty and it's lawful conduct? We have the case of Coates versus Dish Network, and Dish Network is a cable network, and this was decided by the Colorado Supreme Court in 2015. The facts here were that plaintiff was a quadriplegic customer service representative and held a license to use medical marijuana in Colorado. He did so off the employer's premises and claims he was never under the influence of marijuana at work. He tested positive for marijuana pursuant to a random drug test, which is permissible in Colorado, and was fired for violating his employer's drug policy. The issue that was decided by the court was whether Colorado's lawful activity statute protected plaintiff from being terminated for using medical marijuana off-duty where such use is lawful under Colorado law. The holding in that case was that Dish Network did not violate Colorado's lawful activity statute by terminating the employee because medical marijuana use is not lawful activity under federal law, and the Colorado lawful activity statute does not make any distinction between lawful activities under state or federal law. So must employers accommodate marijuana use? The state Supreme Courts in California, Colorado, Oregon, Montana, and Washington, as well as federal appellate courts for the 6th and 9th Circuits, all have held that state medical marijuana laws do not require employers to accommodate medical marijuana use by the workforce. We have a case, another case, Emerald Steel Fabricators versus Bureau of Labor and Industries. In that case, the employer was not required to accommodate the employee's use of medical marijuana because it's illegal under federal law. And in that case, it was an employee who used medical marijuana, and he told his employer in advance of the drug test about his medical marijuana card and his medical condition. A week later, he was terminated. The Oregon Bureau of Labor and Industries investigated his complaint and found that the employer had discriminated against him on the basis of his disability. Then the Oregon Court of Appeals weighed in supporting the lower decision, but then the Oregon Supreme Court reversed it, finding that medical marijuana, although authorized by state law, was still an illegal use of drugs under federal law. A couple of the cases we're going to go through pretty quickly. One is Roe versus Teletech Customer Care Management, and in that case, we have the Washington Supreme Court found that the Washington's Medical Use of Marijuana Act does not protect medical marijuana users from adverse hiring or disciplinary decisions based on an employer's drug test policy. In this case, the employee sued her employer for terminating her when she failed a drug test. The Supreme Court of Washington found in an 8-to-1 decision in favor of the employer, finding that Washington's Medical Use of Marijuana Act provides an affirmative defense to state criminal prosecutions of qualified medical marijuana users, but it does not provide a private cause of action for discharge of an employee who uses medical marijuana either expressly or impliedly, or it doesn't create a public policy to support a claim for wrongful discharge. So again, I think the cases have been very consistent that no matter what the state law is, you have the federal courts and the federal law, which is in conflict, and because of the supremacy clause, when there's a conflict, the federal law prevails. So it's pretty clear in those cases. However, we do have a recent, some recent legislation that changes this up, so, which we're going to talk about in a moment. So there are limitations on the use of recreational marijuana. Wanted to get this in a little bit. There's no law, as you know, requiring workplace accommodation of recreational marijuana, and there are liability risks, certainly, of ignoring use of marijuana. If you are allowing people, if you decide, hey, well, everyone is using marijuana anyway because it's been decriminalized, I'm just no longer going to test for marijuana, and then the employer is in a bind now because if you have an accident at work and it's because somebody's under the influence of marijuana and perhaps you knew that they were using marijuana, that then could put some liability on you as the employer. However, we do have one state now, Maine, which has prohibited employers from discriminating based on off-duty marijuana use. And this is a big deal. This just passed in February of this year. A provision of Maine's recreational marijuana law prohibits employers from taking adverse employment actions for off-premises marijuana use. This law effectively prevents Maine employers from testing for marijuana for pre-employment purposes. It will be interesting to see what happens as a result of this, and if this is the type of legislation that will continue, and whether other states enact laws like this. It would be interesting to see what happens in Maine if an employee there shows up for work and is under the influence, but tries to say that it was off-premises use, maybe in his car before he came to work, and if he's terminated there, then what happens with the interplay of federal and now this new state law, for the first time protecting employees from using marijuana. Certainly, I don't think it would protect someone if they show up high to work, but for the off-premises use. And that can be a slippery slope as to whether someone is considered to be still under the influence or not. And certainly that leads to issues of safety in the workplace, which I alluded to before. How will increased marijuana use by applicants and employees impact an employer's duty and potential legal exposure for providing a safe workplace under OSHA and various state laws? California employers, at least for now, are still able to maintain a safe workplace by restricting employees from being unsafe at work while under the influence of marijuana. So some takeaways to think about and to take with you for those of you who are employers or in a employer advisory situation. Review your employment drug and alcohol policy, whether that's in your employee handbook or if it's a standalone policy. If you do not have one, you need to have one. You need to make policy decisions about marijuana use and what the company policy will be. I mean, obviously, if somebody shows up under the influence, you're going to take the proper steps, just like if somebody shows up, under the influence of alcohol. But you need to decide what you're going to do. Remember that any actions you take are going to be considered the standard to be used for future employees. So if you have somebody who you know is using medical marijuana as they undergo treatment for cancer and the effects of chemotherapy, well, then you've just set a standard, and someone who says, well, I'm using it for my anxiety or my, whatever the other issue is, something that's not as severe as, undergoing cancer treatments, well, you don't get to decide that those who are undergoing treatments for cancer can be under the influence and can use medical marijuana, but that those who have a disability that you don't consider to be as serious, that they cannot. So you really have to think about what the other implications will be of the decisions that you make. You also could have exposure for inequitable application or a failure to enforce of your policies. And this goes not just for drug and alcohol policies, but for any policy that you have in the employment context. If you want to bend over backwards for an employee who's this great employee and, is a really good performer, but then you don't do it for someone who's maybe had a bit of trouble, then there are issues that could come up, because then you can be have liability for discrimination. So it's a really good idea to take a look at what your policies are, what the what your decisions and what your how your enforcement level is going to be for marijuana and for your drug and alcohol policy. And it's a really good idea to have a policy. If you have a handbook and it's not in there, you can just do an addendum and have a standalone policy. And if anyone needs help drafting anything like that, I do that all the time, and I'm happy to help.